Good evening and welcome to LegalTech Live, episode 73. We're here tonight with our guest, Johann Drolshagen. Did I get that right?
You got it.
I got it right. I ask every time, almost every time after the introduction, because I'm not nervous about these things. Anyway, Johann has got quite an interesting career. Found him through the California bar's access through Innovation of Legal Services, or he found me, but he is the lead engineer, web developer, and cloud architect at Brick House Security Consulting. That is essentially his day job, but he's also the chief technical officer and chief information officer of Level Playing Field Solutions, and the technical director for Executionists, one of the solutions from Level Playing Field Solutions. And there's a lot of moving parts here, Johann, so correct me if I'm wrong, but one of the solutions, one of the ones that really inspired me to bring you on tonight, was this Judicial Assessment Solutions, and that falls under Level Playing Field Solutions, does it not?
It does. If you think of Level Playing Field, it's sort of like saying Microsoft Office, and then there's just a whole suite of solutions underneath it.
Excellent. And our guest co-host tonight, my good buddy, Johnnie Finch, North Carolina criminal defense attorney, representing people who have been charged with criminal offenses such as driving while impaired, probation violations, and drug offenses. North Carolina, you can find him at JohnnieFinchESQ.com. He is also the author of the Black Lawyer Confidential book. Thank you, gentlemen, for being here. Thanks so much and thank you to our guests. We got Maureen Blondo from Mobile Helix here and Mel H. So ladies, go ahead and in the chat, when we get to a question, pop it in. We'll be happy to ask it. Johann, tell me a little bit more about yourself, because your CV is long, it's distinguished, and there's a lot of stuff in there. So let's talk about your experience in the legal field. And Johann is the one who corrected me that I was looking for those in criminal justice, trying to bring some of those folks onto the show. He corrected me that the hashtag for that is Justice Tech. So how did you get involved in Justice Tech?
Well, I started back in, I want to say about 2009. Prior to 2009, I was a power user of material management systems, point of sale systems, reservation systems, that kind of thing. And I made the switch over to start developing in 2009. And I got heavy into the, what we call the open source movement. I do my development in PHP in a content management system specifically called Drupal. And I do everything cloud-based, so there's no servers, on site or anything like that, and easy for people to access over the phone and that type of deal. And in 2009, when I returned stateside, I decided to get into development. And one of the first projects I had, it was a very auspicious time in our information age, but one of the first projects I had was called the Online Arbitration Network, and we actually figured out using Web 2.0 standards, which I can go into or not if you prefer, but we could create a platform where people could come and go through dispute resolution using arbitration in an expedited fashion, incredibly cheaply by comparison, financially, and it was considerably faster to do it online as well. So that product launched in 2010 and failed wonderfully. It was, if you look back to 2010, I mean, smartphones were not, and whenever you said the word cloud, everybody looked up. So the adoption rate just really wasn't there. I actually came down to Los Angeles in 2012, as there was considerable opportunity in Los Angeles, and that Los Angeles is so complex of a physical location with all the ethnicities and central, it's just a huge population. It's just very complex to creating systems. So if you can do it here, you can apply it pretty much anywhere. I had actually intended to work with the superior courts here in Los Angeles. However, at that time, as sort of repercussions of the economic downturn, those those opportunities, the entire arbitration or dispute resolution arm of the courts was actually eliminated statewide, county by county. So I didn't really have an opportunity to continue with that. I kept that platform, and I kept other things, and what I realized I had done was I had created a case management system from the perspective of the court, not something that would help lawyers necessarily, because all of my solutions make the assumption that lawyers being involved is actually going to screw things up more than it is, solve problems. So roundabout, and I know Melinda Hess is watching tonight. Melinda and a good friend of hers were involved with a couple of diversion programs with the Los Angeles County City Attorney's Office. And this was 8 different programs, 6 of which were criminal diversion, but highly specialized. Gang activity, prostitution, whatever the case, whatever the bulk of charges were, as well as one that was civil and then one that was administrative. And it's a really interesting thing that I think is finally coming ahead in 2020 that's happening with the courts. And the courts are getting overwhelmed. Courts are starting to fail to maintain the demands upon them. And while I absolutely commend any prosecutors that start using diversion, as for example, Mr. Gascon up in San Francisco has eliminated the juvenile court system essentially by integrating diversion into his program, I got involved with the city attorney's office to provide them cloud-based, lightweight, very inexpensive case management systems so that they could put people through diversion. And it would be simple things like small cases where jail was not on the table, or incarceration as a whole was not on the table. And it would be something like first-time offenders with nonviolent accusations, charges, and then not drug-related. And I should point out the drug-related had its own separate diversion path. But in this case, that's a huge amount. And I'm talking in the juvenile cases, which LA County still hasn't incorporated. But when we looked at the arrest records, and we're going back all the way to 2015 because it was compiled in 2016, presented in 2017, approved in 2018. We're still waiting for it to be implemented. But that low threshold actually took 91% of the cases, of the juvenile cases, out of the court system, which was an 80 to 90% savings on the expenses of the system in order to handle those cases. So the impact of using diversion is dumbfoundingly high. And we're showing incredibly low recidivism rates because of it. And by low, by comparison, if you look at a national average, you'll see numbers anywhere from 65 to 75% adult felony recidivism. And if you get them when they're young and you put them through a diversion program, we're seeing single-digit recidivism.
Is that your experience as well, Johnny, that early diversion it certainly reduces recidivism?
I'm not hearing him, I'm afraid.
He's not. He hasn't said anything yet. He's thinking it through.
Oh.
Depends on the individual. It always depends on the individual, what's going on. If it's a juvenile and the house is not in order, it's likely you'll see them again. I haven't found any patterns as to why people end up on the other side of the table, one way or another, as to poverty or rich or not. I mean, it's personal decision. So
then maybe the data is what we need on that, Johann, and your data is showing that that the diversion reduces recidivism.
Yeah, absolutely. Matter of fact, the name of the program that Melinda was a participant in was the Neighborhood Justice Program. It's out of the LA City Attorney's Office. I don't know who's running it now. It used to be Jose Egurbide, who's a great guy, very caring individual. And there are, public reports that are available, publicly on the internet and that kind of thing, where they actually count their recidivism. And it was a program that was put out by, I believe, the primary pilot supporter was the Center for Court Innovation. with backing from, I believe, all three of the big ones, which is Arnold Foundation, MacArthur Foundation, or pardon me, it's now Arnold Ventures, MacArthur Foundation, and California Endowment. And matter of fact, some of their programs, they've got their heart program, which works with the homeless, that has actually been gone from the city attorney's office and has been expanded countywide, and is doing just amazing work trying to head off homelessness by removing what we'll call court issues in advance. We find a lot of people that are incredibly vulnerable, say they're in Section 8 housing, and if they have even an infraction, they can lose their Section 8 housing. If they don't take care of that, it escalates to like a failure to appear or something like that. So they're literally going into the communities to give people opportunities to be able to get that off their record so that they can maintain their support.
Okay. All right. And so this was the inspiration for your action in or early activity in justice tech. And from that, you now have level playing field solutions. And what inspired me to have you on the show was this judicial assessment solutions.
Yeah.
Tell us a little bit about that.
Okay, so I'm an advocate of ending cash bail bond, and there've been a few people that have tried to make it work. Inevitably, they always kind of run into a roadblock, and the people that are objecting to it as it's hard to track. We don't want to just release everybody. They need a tool. They need quantification. They need all these things. And interesting side note, or a good example of somebody that I hope will be using this very soon, is Harris County in Texas, which includes Dallas, by the way, just had a federal judge throw out their cash bail bond system, thanks to, and if I get any of these wrong, or if I forget anybody, I apologize, but it's thanks to the ACLU going in, following up on some accusations that it was being misapplied or inappropriately applied, generally in bias. They put cameras into the courtrooms and caught multiple judges that were dealing with 100 or better of these motions a day, but they were catching them in error almost 30% of the time. So, and this isn't against these judges. These judges have got a hard time. I'll support the judges. I'll even support the prosecutors, the good ones, and I'll support law enforcement. But when you are in error 30% of the time, you've got a real problem going on. And for those that don't know, and you can find these statistics available out there as well, depending on the jurisdiction, and California is one of the worst, we've got 60 to 75% of the population of our county jails not convicted of anything. Right? They're sitting there based on, not being, they're living paycheck to paycheck. They're not able to cover a bail bond type scenario. And frankly, and I'll call the prosecutors and the law enforcement out on this, they'll jack up those charges so that bond goes higher, so that person's more likely to sit in jail and then more likely to take a plea and go on from there. So in LA, yeah, go ahead.
When you say you caught the judges in error, was it because like a error in that when they were signing the paperwork, or an error as to how high the bond was supposed to be based off the guidelines?
How high it was based on the guidelines.
Oh,
and they were finding bias in their behavior as well.
Okay, so they were looking at the paperwork. They were looking at whoever the client was or the defendant was, and they were they were high. They were high. That's not an error. That's they did it on purpose, right?
Yeah, absolutely. Okay.
I was thinking that they were looking at the paperwork and maybe they hit the wrong, like 100,000 instead of 10,000, just because they had to do 100 bonds. Oh, okay. So they knew what they were doing.
Yeah.
Okay.
Yeah.
But that's 30% of the time, you're saying. That was
exactly.
Okay.
By the standards that they're issued and what they're supposed to be doing, they were not in compliance 30% of the time.
Okay. Thanks for that clarification, Johnny. Also, I don't want to cut you off there, Johann, but
sure.
We do have Alicia Kinchlow, Mitch Jackson, and Carol Williams watching over in the Facebook group tonight, because tonight Facebook decided to play nice. So, and of course, they saw Johnny's face and decided to join. They've seen my face enough, but we don't see Johnny enough. So go ahead. So So this is, tell us a little bit more about Texas there.
Okay, so basically the federal court, it's the first time that the federal courts have stepped in and said the way it's being applied is far enough from accurate that it needs to be stopped until it's no longer that way, until it can be repaired. So that's one scenario. That's a little bit peripheral. But now in California, we've got SB 10, which is coming up for a referendum. And this was an issue pushed by the Chief Justice of the Supreme Court of the State of California, which I love the idea, again, of the elimination of cash bail bond. She used a constitutional argument, which is the appropriate thing to do, which I'm glad she did. I'm about to say something not nice, so I want to make sure I get all the nice stuff out of the way. But even with a constitutional
Johnny's ready for it.
Yeah, even with a constitutional argument, the ACLU came out against it because what she did, sort of in the way it's written, was she didn't commit to the elimination of cash bail bond. She granted greater discretion to the judges to consider the elimination of cash bail bond, or whether or not it should be applied. And unfortunately, I can't support that. It's kind of, it's better than nothing, but it's not far enough. Mm-hmm. You know, so that's what I say. I don't really want to be critical because I want to keep moving in that direction, but I don't want to take this SB 10 and consider it done. Mm-hmm. And unfortunately, now there's a huge lobbying effort, which is backed by, it's not even bail bonds, it's insurance companies that back bail bonds, for people that don't know it, because all you're doing is running an actuarial table as to the likelihood of the person being able to return, and you're taking a leverage against some form of equity that they've got. So that there's really no way for the insurance company to lose, but we're also not really here to make business for them. Johnny, how do you feel about that?
Let's just keep going.
He's getting fired up.
Let's just keep going.
Okay, so what I did, and I looked at a couple of models that are already out there, and all I did was I automated the models, right? There are very few things that are considered relevant as to whether you'll get compliance from an individual in terms of showing up for court. Age, believe it or not, is a huge issue.
That makes sense to me.
Yeah, and you'll see I put the chart on the site where the highest number of offenses, and unfortunately we don't have access to the juvenile numbers, although I'm fine that we don't have access, but it starts at 17 until about 25 years old, and that's where easily the highest number of offenses are. Then it drops to about 45, and if you make it past 45 without a conviction on your record, one, the likelihood of you committing a crime is considerably less, and two, the likelihood of your compliance with whatever orders and returning and not committing a failure to appear and that type of thing reduces to damn near nothing. So we take a look at that. We take a look at the number and type of charges that the person has. You know, is it a misdemeanor, is it a felony, and is it violent or not? Then we look at any other pending charges that may exist that haven't been resolved yet. And again, how many are there? Is a misdemeanor a felony, and is it or is it not violent? Then we look at previous convictions as well as previous incarcerations and any previous failures to appear. And it is an algorithm, but that word shouldn't scare anybody. It's just like keeping score in football. Different things have different point values. You add them up, and then we made a visual display that comes out and shows a gauge that shows the whether or not they're likely to reoffend, whether or not they're likely to reoffend with violently, and that type of thing, and then an overall recommendation. And one thing to know about the gauges, and anybody can go to the website now and actually run through this and actually test it and see it. And we gave samples so that you would have a dashboard to see the end results. We gave it a sample report as it would look. It's not the one you ran, but it is a sample report.
And Mitch makes a clarification that these are alleged offenses, correct?
Yes, of course. Yes.
Right.
Sorry. That's my non-lawyer background.
Sure.
Stepping in. So and then we issue a report, and that report can be either printed off or emailed or whatever into the whether it's the court or if it has to go into the record, it goes in the record, and it can be handled by pretty much any entity. depending on the jurisdiction, some of these assessments are run by probation departments, some are run by the courts, some can be run by law enforcement in what is typically deemed a catch and release scenario, where they don't hold someone, but they need an assessment. They need to justify what their assessment was, and they can even be run by prosecutors or public defenders.
Okay.
So, and that's one assessment tool. We can create as many of these tools as we have time and take the time and actually put into place. And we can have a sentencing tool, we can have a probation assessment tool, we can do all these tools. And the beauty of it, oh, sorry.
Yeah, so let me ask you that. Who's going to use this judicial assessment tool? Are people in Johnny's position going to use this to fight with the courts over the amount of bail that's being set?
They sure could, yeah.
Okay.
Most of these assessment tools, and this sounds a little bit strange, but when I was in college, I was studying political science and psychology. I was going on to anthropology, and prison culture was a thing that I studied, and I actually did assessments at a mental hospital in Missouri for those that were arrested with criminal issues or accused of criminal issues, and there was a mental component. Then they would need to go through the assessment, and I was nothing more than an intern for 2 summers learning these, but they were very enlightening to me. So generally speaking, this would be something that would actually be done at intake or immediately prior to, say, between the arrest and the arraignment, where a bail arrangement would be made, and it gives defense counsel an opportunity to argue for a lower level. And in some cases, if it was used properly, in my humble opinion, it would actually eliminate that step entirely if, for example, you have a first-time offender, let's say it's a low-level felony and no previous history, then they can basically walk into court with almost a stamped ROR. And now the beauty of this system, which is built on another platform that I call a quantum website, is this site is available in every jurisdiction around the country independently, so that if we have to change one of the components of the assessment, which we do in California, by the way, we can change that for an entire state or a county or a municipality. So, for example, Governor Newsom in California just signed into law an increased, the best way I can say is an increased path to diversion and release from incarceration for anyone that's considered a primary caregiver with dependents. So, for example, in California, we have that, but in Nevada, we don't. So in California, we reduce the score by an additional 25%. That's an example, that's not an exact number. But in Nevada, that's not a component. So we don't include that in the calculation in Nevada. And because of this, we can give this tool unique to each jurisdiction, We let each organization that needs to do it. So in some states, it may be the courts, in some states, it may be law enforcement or probation or whatever the case may be. We give them unlimited number of users, unlimited uses of the assessment tool itself. We charge them $20 a month, and that's it. And then at the end, and this is important across the board, there are 2 schools of thought on this, and we allow the jurisdictions to choose the path, is that we collect demographic information. And we standardize that demographic information across all jurisdictions. By default, it's turned on. We then sanitize those with no personally identifying information. And we can present graphical data. And I apologize, this is the one part that's not available on the website right now, because this is the part we've been wrestling with the most. But you can see not only things like the arrests per gender or per race or sexual preference or whatever the cases we want, and we get into what's their marital status, do they have dependents, are they a primary caregiver, and we can see that cleansed information, and we can map it and group it. So for example, we can have all the jurisdictions in California with their individual information, then we can have the information for all of California, then we can have the information for all of the United States. So we can drill into that information. It's our intention to make that information freely available, because it does not include personal identifying information.
Okay.
And we have some things that people can use that data for their own purpose.
Okay. All right. So we have a question from our friend Alicia Kinchlow over in the Facebook group. And I want to welcome Aaron Levine as well as here. And Morris Lilienthal is also watching over in the Facebook group. So thank you all for being here. I will take it fully personally that I haven't seen all of you in a while. And I will claim that it was Johnny who brought you in. But Alicia asks, when looking at the data to make those decisions, how do you account for systemic issues in the criminal system? Wouldn't the data you may be basing these things on be tainted by historical discrimination in the system?
Absolutely. There's just no way around that, or at least not that I've figured out. One of the challenges that we know we've had, and I forget if we were talking before we went live or after, but one of the challenges that we know for a fact that law enforcement will stack charges to make it harder for people to meet bail. We know prosecutors will do the same thing. They use that as a tool. Johnny, to clarify for you, they use it inappropriately as a tool. It's not accidental. And I can't do anything about that, unfortunately. But because we can quantify the information, we can track it. So there is no feedback loop that, for example, what gets us to go all the way to what were they charged with, what survived the preliminary hearing, what were they eventually convicted of. I don't have that full loop, okay? If nothing else, though, let's demonstrate that we can track that information, and as new next generation case management systems come into use, expect that we should have that information from those case management systems. And we can do it in the case management systems that we do for diversion programs, including follow-up for recidivism that are scheduled to be, if it's diversion, it's typically within 2 years. So you'll do a recidivism check at like 6 months, 1 year, 18 months, and 2 years, and then release that person from any liability for that issue. Because one of the things with the diversion program is it's diversion on condition. So if you reoffend, that old charge tends to come back as well. Okay.
So we do have another question, this one from Mitch, and directing it towards Johnny, who's being uncharacteristically quiet tonight. It must have been a long day, Johnny. Mitch asks, how could or would you as a criminal defense lawyer use this type of service?
First of all, I'm only being quiet because this gentleman right here is telling my whole life. And it's kind of like flash. It's like, so this is the thing. The system that he's created is something that is needed, obviously, for indigent or poor or the disenfranchised, because those are generally the people who can't afford, the $100,000 lawyers. And while it would be perfect and for obviously public defenders or anybody, and I do a good considerable amount of indigent work, is because I have the printout at that point. So regardless of whether the judge wants to appreciate what I have a record of what's been going on from what I can understand is I have this printout. Judge, this is what it's supposed to be. This is what, based off of everything that's happening in this county, this is what it's supposed to be. Now, there's only going to be a certain amount of attorneys who are actually going to present that to the judge. Those are generally going to be the people who are representing the indigent or doing a lot of indigent work, because obviously judges recognize individuals, and we have great judges in North Carolina, but judges recognize the individuals who are getting paid $100,000, $200,000 to have these cases of people who are going to keep them on the bench. Not saying that the judges would treat anybody differently, but the thing is, if I'm walking into court, maybe I'm an out-of-county attorney, maybe I'm an attorney who does a lot of indigent work, and I'm saying, well, Judge, this is the thing. I understand you usually rule this way. I actually have a little record of everything that's supposed to happen. This is where the bond is supposed to be. And the only thing I have to do is say, Judge, rule however you want to rule. I just want to put this in the file, right? Regardless of what, hey, you think it's supposed to be 100,000. I think it's supposed to be 15,000. I'm just going to put this in the file. And I just ask it to be filed, and that's it, right? What the judge knows then is there's a different check on the system. Because why in the world would you have this individual's bond at 100,000 when based off of everything that's happened, the factors that you've named, it's usually $15,000 or it's $4,000, or they should go on an unsecured bond. I'm just going to slip it in the file. That's the record that you need. But the only people who are going to have the guts to do that are the public defender in North Carolina. If the public defender, see, this is the thing about the public defender's office in North Carolina, the head public defender is appointed his job by the chief judge of the county. Okay. And so public defenders have to take their cue from the head public defender. So the head of public defender wants to keep his job. So are the public defenders going to be allowed to have this paperwork? Okay, then you have people who take indigent work, and then your more progressive counties. We have Durham County, where Duke University is, Coach K. That's one of our more progressive counties. Mecklenburg, where Charlotte is, another progressive place where you have a lot of poor, but a lot of more progressive places. But in your smaller counties, where I represent individuals, is going to be a lot more less. So we may have 5 attorneys in the county. And the last thing you want to do is upset a judge. Now, when do you get a place where you have this paperwork, and even to circulate it? If I had some a tool like this, what I would do is at the next bar meeting, I would call someone and say, hey, there's this tool that is out that when it comes to the way I would serve it to them is, hey, there's a tool that's out. I think it can make things quicker. It's a device for DAs. It's a device for myself. But what it does is it does this assessment and it gives it to us. The clerk can give it to us. She can print it out. She can give it to us, and we can have it beforehand. It's kind of like a little cheat sheet for everybody. What I actually know is it's going to hold that judge accountable, and it's not my idea. If the county didn't want to adopt it, I would always print it out anyway, because I would be happy to go into court and just say, hey, listen, I'm asking for $5,000 on the bond. There's this little computer system. I don't know where it came from, California, one of those places, but it's kind of neat. I just want y'all to look at it for a minute. It says that he's 17 years old. He stays with his mom. He's never been in trouble before. And I just want to put it in the court file, because what happens is there's a level of accountability. And see, what happens in North Carolina is that law enforcement pretty much rules. So whatever they assess the case at, whether there's lawyers or not, which we have some great law enforcement officers, the fact that they're bringing the case forward, they lean on DAs because district attorneys generally, if you're good with the sheriffs, then you can get your job back. Not saying that anybody's doing anything crooked, but if I could just have a piece of paper, I don't have anything to do with the information that's put in the paper. It's fine. It's a third party.
Comes from a third party.
Yes. I gave it to the clerk, and they gave it to me. I would be happy to give that to the judge. I wouldn't be afraid to give it to the judge. So I was saying, hey, judge, here's a sheet of paper. Let's put it in the file. And then you have these entities that are coming from the stronger counties who would actually not be afraid later on to say, hey, listen, I think these bonds are wrong. And if a judge is ruling over that, if it's supposed to be a suggested $5,000 and it's $100,000 bond that the judge is asking them to post from these prosecutors who are now DAs, it makes them think differently. So,
and was that part of the plan there, Johann, in this? Is that
it's really close. It's really close, because what I saw or what sort of motivated me was again, being involved with the city attorney's office, knowing the diversion, wanting to push restorative justice standards. I actually saw that Arnold Ventures created sort of an abbreviated version of the same thing. I definitely took it to the next level, and like we do different calculations. We can tell, we get the person's date of birth, and we can tell then their age at the time of arrest as all these other things. And we can extrapolate the information further. But I saw them, which absolute kudos to Arnold Ventures, they went out to financially incentivize jurisdictions to consider the elimination of cash bail bond. And they knew that the first thing that everybody needed the moment they considered it was a way to have an assessment that would justify the decision. And that's the part where Johnny hit the nail square in the head, because we don't actually go in and say the bail should be this dollar amount. We start with, this person's a low level of likelihood of reoffending, high level of attending future court hearings and that type of thing. So that person should be ROR. Then we do, the second level is a release on conditional, which could or may not be done by a probation department. It could just, the condition could simply be, you don't get any other charges in the time we're dealing with this, and then you stay free. And then there is an opportunity for cash bail bond. And then there's also the opportunity, knowing full well that the other end of the spectrum has to be represented, which is this person needs to be held. So those are the four basic assumptions that we can make. We can change those. Again, the fact that we can change this from jurisdiction to jurisdiction allows a lot of granularity. California may choose to do this and implement it statewide, but you may have a county in North Carolina that says, I'm tired of waiting for the state to do this. And the chief judge for the county says, I'm going to implement it for the county. And we can do that too. That's the beauty of the quantum platform that we've got this built up.
Excellent, excellent. I want to thank Colin Levy is also watching now, and Chris Conjero has been here. So if you guys have questions in the Facebook group or the Zoom room, please ask them. And Johann, has this been rolled out to anyone yet? Or you have any test cases or use cases yet?
You were the first one.
Okay.
Yeah. Again, I haven't finished the quantification yet. There's still some text that needs to be input and edited as to what the components are and why they're important and how they're relevant. But I reverse engineered it, which is I started by creating the algorithm and making sure that I could give the output, and then I did the interface, and then we'll do the launch. I'll be honest, if anybody wants to give Arnold Ventures a call, and I'll make them a hell of a deal on the package, because I'm not actually looking to run this as a business. My business is creating platforms like this, not necessarily running it. So I would love to see it get legs. I'd love to see somebody take it to the full measure. That's just not who I am necessarily. If anything else, or let's say it differently, if nothing else, what I want to do with this one particular assessment, knowing that I can add a multitude of other assessments down the road, is I want to demonstrate that it's available. And when judges start thinking about this, or probation departments start thinking about this, when they throw a Google search out there, I want something to come back that's not a piece of paper or a PDF form that says we can do it on the cloud. We know the scope of what we want. We've got the scale of what we want. We can customize it to what we want. Basically, all the answers are yes. And then the giant price tag at the end of the day is $20 a month, so that they can't say no. And that's all we're doing is poking the bear.
So you want to make it available for others to run with, is essentially what you're.
Oh, I would gladly have somebody else run with it. Absolutely.
Let me say this. I am a true believer. I would, for the hell of it, run for district attorney in my district with his platform. Like I would like, listen, forget. Okay, yes, obviously we have to. We're not criminating marijuana anymore. With just that one thing, just so everybody knows that I have it in North Carolina, I would run for district attorney with that platform, with that assessment, run it by the judges. I might lose, but everybody would hear about it in North Carolina if it was something that I could have, because it's that important. And everybody's been talking about it. Everybody's been keying around it. How do we do it? But we've never had a source to just come in and say, hey, look, this is what the computer said. We don't have anything to do. We don't have anything to do with it. This is what the computer said. I just want to, can I get that printout? Let me give it to you. I will run for district attorney on that.
Johnny, you got to see what else I got, man.
Well, there you guys. This is how it works. I bring in a guest and a guest co-host and try and make an arrangement for you guys to get offline and run with the ball.
Absolutely. And you know what? Let me follow up on that one statement. I'll keep it short because I know you're moving on. I have never in my life seen as much support for the amount of change that's going on right now in this industry. And not the legal industry necessarily. It's happening in the legal industry. It's catching a lot of attention in the legal industry. But this is why I refer to it as the justice industry.
Right. And
it is changing. The pressure is there. I happen to think 2020's got a perfect storm of shit coming to the courts, where the courts cannot handle the volume, and it's forcing change. So it's a great time.
Anytime I go, I agree with Johann there. Anytime I go to post something about in my day job, experts.com, and I go to post something that's criminal justice related. And this is just basic, very basic, but it'll give you an idea of how much things are changing in criminal justice. Anytime I want to hashtag something criminal justice, what comes up is criminal justice reform.
Right.
That's my choice. So it's being used that much these days that I can't just do criminal justice. Colin says this is really cool, and not just cool, but an important effort to bring transparency to the judicial system. And I think that is the point that Johnnie is making in the run for DA, is this would bring one more level of transparency to what we all know is a very opaque system for most citizens.
So intentionally. Johnny, I got a question for you, just because I'm doing this in LA, so we got our own little source of problems down here. Do you have the Brady cop issue in North Carolina?
Is that remind us, because I think I know, is this the one where you can't get the files on police officers' history? Is that the case law you're talking about?
It's a little bit more nefarious than that, at least I know it's been found in multiple metropolitan areas in California, because I know Oakland's got a lawsuit, Sacramento's got a lawsuit, San Francisco's got a lawsuit. What happens is, and in this case it's specific to our sheriff's department, but we're certain it's in the police department as well, is the sheriff's department of Los Angeles County themselves chose to handle violations of the law of their officers internally as human resources issues,
right?
Which then blocked the ability for these officers to be held accountable in court. So, for example, they would be planting evidence, or they would lie under oath, or they would hide exculpatory evidence. And the Brady lists, which were found about a year and a half, 2 years ago they were uncovered by LA Times, found that the prosecutors had entire lists of officers that were not allowed to testify because they committed some level of moral turpitude. We're still going through the legal battles of getting those lists out, but it's so bad in Los Angeles. And if you go back and watch an old movie, which is great, is the movie Colors. Mm-hmm. We have actual gangs in our sheriff's department. And just so we're clear, because I will back up law enforcement, but these assholes, these banditos from East LA can kiss my ass.
Yeah.
All right. So we've got actual gangs in our sheriff's department, and we've known about it for 30 years.
Yeah. And this is, Mitch points out, and as you were summarizing that, I was going, no, I've read this. This is a California. I think the Brady issue is a California issue. And there's also, correct me if I'm wrong for those California lawyers in the Facebook group right now, but I think there is legislation that prevents lawyers from accessing these backgrounds that are handled as human resources issues, even in civil litigation in California.
Yeah, it's because the records were considered personnel records.
Personnel records.
Previous to human resources, they were personnel records.
Right, and I believe that is legislation. Yeah, I believe there's legislation that protects those officers, but we found out as we've gone on that some of this, and again, this is not a knock on solid officers. This is a knock on those
exactly
doing dirt.
And there's a lawsuit going on right now with the county supervisors, which is giving subpoena power to a civilian oversight board that is supposed to both protect the officers that are not a problem, but also allow for some transparency to finding who the officers are. And of course, we've got, I want to say it was Ventura County who took the last opportunity before the timeline to go out and actually delete all those records and burn the paper records before that order came down. So unfortunately, this is one of those levels of corruption that's starting at least in the awareness of the top.
The awareness certainly is growing, and we've got.
Let me tell you how bad. Let me tell you how bad it is. This is a true life example. Back when I was a super baby lawyer, I'm kind of a baby lawyer now. When I was a super baby lawyer, I had an officer who I believe wholeheartedly had planted cocaine on my client. Couldn't prove it. Didn't know how I was going to prove it. I got a call from a probation officer who said, "Hey, listen, man, I got some information for you." I went over. Previously, this officer had assaulted someone in a driving while impaired room, and he was being fired for that. He went over to 2 or 3 different law enforcement agencies, and this previous one, and in the same place, he had actually, the guy didn't want to take the breathalyzer, and so he beat him in the place. He beat him because he didn't want to take the breathalyzer. I don't know what the guy said to him. I don't know any of these things. As a baby lawyer in Northeastern North Carolina, I'm like, this is great. I'm going to be able to get this information in. So I go back and I'm looking. I'm like, we should be able to get this. We should be able to get this information in. I get this information to the prosecutor. The prosecutor, who I'm thinking is, when she hears this information, she's going to be like, oh, I wouldn't want to put this guy on the stand. Johnny, who is a reputable lawyer in our community, is saying, like, he thinks this guy is dirty. Now, my guy, obviously, he had drug charges before. So if you have someone who's been charged with a drug offense, it's very hard to prove that they didn't have drugs on them at that time. For I had reason to believe that the guy would tell something was not true. So I filed all the appropriate motions that I had to the court because I wanted the information from the last 3 reprimands that this officer had, right? And I wanted that to be able to be brought up on cross-examination. You don't have to, I'm not asking the judge to not let him testify. I'm saying, I want to bring this information up. So we get into court, we have the hearing, and I ask about this. And I was like, Judge, well, there's information that the jury needs to know. There's information that you need to know. And he said, Madam Prosecutor. The prosecutor said, we've done ample investigation in this, and we found nothing. And I say to the judge, well, what is this investigation? And she says to the judge, we asked the officer, and he said it's not true. Any of these things.
That is...
Yeah. Hero accountability on that prosecutor as well.
And the prosecutor should have a duty to disclose, do they not, Absolutely. Johnny?
We asked the officer, was this true? And he told us, not that we asked his supervisor, right. Not that we pulled the file, not even they tried to, could you at least make a call to this gentleman to find out if this stuff is prosecuted? No. This is my case. This is my officer. I asked him. He said it's not true. And he got fired with my client. I think we got a hung jury, and we retried it. He was convicted. He went, and then he was fired later on from that department, and then moved to another department where he's doing the same shit. So yeah, whatever y'all have in California, in North Carolina, man, we're still in the dark ages.
Well, Mitch has said in the chat, Mitch said he's had this come up, and he's brought motions to disclose this info in California, and that's handled in camera. So it's kept away from the jury there. Alicia says you should reach out to Philly as they have a very pro-reform DA at this moment. So Philly may be somewhere to target for you, Johann.
Thank you.
And Alicia also says she wants to hear more about what else you have cooking. I'm not sure we're going to have time for that tonight, so you're already going to have to come back. Do you guys have, the two of you have another 15 minutes, because we got a pretty active crowd here tonight? Can we go?
I'll give you all the time you want.
All right. Is that work for you, Johnny? I know you got little ones. Can you go 15?
My wife literally gave me 10 minutes.
10 minutes. All right, we'll wrap it up in 10 minutes. Here,
I can show you the tape.
That's fine. We hear it. Oh, Mitch says that was a pre-trial comment. Yeah, I'm so far out of this group, out of the having to deal with this stuff. I don't recall how all it works. And let's do a 30-second recap. Claudia Johnson's here from Pro
Claudia,
Bono.
I want to meet you. I saw your episode the other day. I desperately want to meet you.
Okay, so you hear that right there, Claudia. She asked, so can you do an elevator pitch for judicial assessments, because she got here late? Can you do?
So the elevator pitch is that we have a standardized tool that is distributed nationwide that can be altered and customized for each individual jurisdiction throughout the entire country, which, by the way, is over 50,000 jurisdictions. And it's cheap, $20 a month for unlimited users and unlimited uses of assessments. And we can we're already planning on putting other assessments onto this platform that can be used by any number of organizations and that type of thing, with sanitized, quantifiable reports resulting from the use of the tools.
All right, there you have it, Claudia. There you have it. And Colin says, what I think is a great theme underlying this is the fact that LegalTech needs to focus not just on cool tools for companies and firms, which we spent a lot of time on last year on the show, but more importantly on bringing judicial system into the current era through better transparency and fairness for starters. And I can't agree with that. It's why I've been reaching out to computational law and justice tech now that I know that that's the terminology, because I think this is legal tech, whether or not it still has to do with our legal system, our justice system. So that's why we're doing this, gentlemen. And Carol Williams says, this is really fascinating. I'm interested in which jurisdictions will use this. So, Johann, I don't think we have the time to go into all of that tonight. So you're just going to have to come back, because it looks like Johnny has to come back because we've got a very active crowd who's very interested in this information.
That'd be great. I'd love to come back. I will send you a list of all the platforms we have and everything else, and you can pick what you want to talk about, or maybe send a poll out to them and see what they want to hear about.
Yeah.
And I'll be happy to talk about any of them.
So which jurisdictions would you like to target first, other than Philly, obviously, and Durham?
Well, I hate to say it, none of it matters to me. It's not, there's no weight to it. It's like there's no boxes of files that I have to move around. So it's all lightweight and it's all cloud. What I would like more than anything else, I would go back to the Arnold Ventures and I would say, if their pilot program, or somebody from MacArthur or somebody from Center for Court Innovation says, we want to do this pilot program around the country, I want to let them use it and see how far they can distribute it, because it's not going to cost damn near a thing to have it nationwide. So, and as much as I love those organizations, my only criticism of them would be is that when they go in and they do the research, and there's tremendous professors doing research and accumulating huge amounts of knowledge, but when they put out the pilot programs go out to like 5 people because of the limitation of funding, instead of going out nationwide for something that, if I were to build this for a client, it would cost maybe 50 grand. Maybe. And that's even probably an exaggeration, because I think I've only spent about 40 hours to build it myself anyway. I still probably have another 10 hours of development to do the quantification. But, use 50 grand as the benchmark. You could have one LSC grant that would do it for one location, or one LSC grant that would do it for the entire country.
But the crazy thing about that is, and she mentioned Philly, I'm imagining that the district attorney in Philly is probably trying to do things the correct way, because there are standards or benchmarks for these bond systems that you had. It's the small counties like mine, where you have these district attorneys who are now judges. They do things a certain way, not because they're right, because that's the way that they've already done them. Right. Because they can run cases a lot faster, like you mentioned in the beginning. These district attorneys who are now judges, all they know is the longer people stay in jail, most likely they are to plead to something, the more likely the docket is to get smaller. So while you could get them in Philly, and I'm sure they're trying to do it the right way, it's the smaller counties when you put in this paperwork, this constitutional paperwork on these judges, where you're saying, hey, look, I'm just putting it in the file. You don't have to do anything with it. But if it's an unconstitutional bond, it's an unconstitutional bond. Man, I love this, man. I love Johann.
Listen, Johnny.
Are you in California?
I am. I'm in Los Angeles at the moment.
Okay. All right. I got a lot of friends over there. I got to come meet you, brother.
Yeah.
My heart goes out.
And let's do this. Because it is almost time before Johnny's wife comes in and starts abusing him on camera. Let's tell the audience where they can get in touch with you both. Starting with you, Johann, how do they get in touch with you?
What I'll do, hopefully to make this easy. Let's see if I can do this without screwing things up too much. How's that?
That's good. That's good. Now, for the podcast listeners on all the podcast channels, we'll need your audio for that.
Certainly. So you can find me. My email is actually ceo@brickhousesecurity.consulting. That's a unique email. It's not .com. It's .consulting. You can also find me at levelplayingfield.solutions. That shows you some of the other things that we've got that we'll talk about in the future. This particular tool, anybody is welcome to go and play with and try out now, and that's at judicialassessment.com. You can connect with me on Twitter at JDROLSHAGEN. You can see my full CV at johanndrolshagen.me. I'm putting together a sandbox for my 2 platforms, which is not quite done, but follow it and you'll be able to see the improvements, which is quantumweb.site. And the other one, which we haven't even touched on, and this is the one that's going to get Johnny elected, which this is a marketing tool called masterblaster.solutions.
Excellent. Excellent. So for those who are watching, they see that on their screens. For those on the podcast, you can find Johann all over the place. He is quite responsive on Twitter as well. We've been communicating there. Johnny, where do folks get in touch with you if they're in trouble or if they just want to urge you to run for election or if they just want to talk to you because you're the coolest guy?
If you want to find me, all of those places where you saw Johann at, I'm going to be there. This gentleman has just given me life into being a lawyer again, just when I was feeling like it's just not going to work. This technology that he has, man, it is incredible. But Johnnie Finch on Facebook, on Twitter, I'm Cool Relax, COOLRELAXED. On Instagram, I'm Cool Relax, COOLRELAXED. But wherever Johann is at, that's where I'm going to be. This is my guy. Nick, obviously, he can always get in contact with me. I'm just so happy tonight because I was feeling a little low before I came here today. But, technology rules, in the courtroom, especially in these old, because you can still smoke in the courtroom in North Carolina. You know that, right?
Oh, is that where you're at?
No. You can't do it, but that's where we are as far as being archaic. And so, I just appreciate. I appreciate the mind that you had to come up with this because when I heard it, I was just like, every single meeting that I go to for the indigent, for criminal justice reform, everybody's talking about how do we actually get it to the forefront. But as far as a system that we could have that we could distribute to the courts and just hold them accountable, we've never had it. So, this is like Christmas for me.
Excellent. Well, there you go. My pleasure, Johnny. Thanks for coming on. Thank you, Johnny. Thank you, Johann. I appreciate it. That is quite the endorsement there, Johann. I'm sure you're getting this from other criminal defense attorneys as well. So,
yeah.
But that is a heck of an endorsement. I thank you both for being here. Thank you, Maureen and Mel, for joining on Zoom. Thank you, everybody, for joining on Facebook. We hope you all have a great night. To my guests, don't disappear right away. Johnny, I know you have to, so if you have to, go ahead and I'll message you afterwards. But thank you all for listening. Come back next week. We'll be on with Instant Attorney. That's myinstantattorney.com. That'll be episode 74. This is another Access to Justice push, episode 74, and will be guest hosted next week with Aaron Levine of Hello Divorce. So stay tuned, and thank you, everybody. Have a wonderful night.